Hi, Charlie.
Hi, Jack.
Just one thing.
Yes.
It seems to me if we put our shoulders to the wheel, we could probably finish tomorrow. I'm not saying that's
I agree.
Whether you're happy to close tomorrow afternoon or whether you want more time and therefore dribble into Friday. I don't feel strongly.
I don't have much of a view either. It probably depends where we get to by the end of today.
Yeah.
I think, but
I think we may finish Barbara, maybe do Hill and Chief, maybe. I don't know.
Yeah, that's maybe. Probably what I think is where we're going to end up, I think. And then we can have a break during the course of tomorrow. I won't travel back anyway tomorrow. So even if we finish, so we could do the cross-examination, have a couple of hours and then close, I don't know, 3 o'clock.
Yeah, fine. We'll leave it to the inspector then.
If the inspector wants to, I'm very happy either way.
Yeah, fine. Thanks.
Right, okay, the inquiry is resumed. We're going to be beginning cross-examination now of Ms. Greengrass. Any matters to raise before we get into that?
No, thank
so
you.
Just one, sorry. So just one matter, I meant to say it earlier. Miss Greengrass tested positive for COVID over the weekend, which is why she's self-isolating and not in the room with me and Mr. K. I understand she's got mild symptoms, but was eager to keep the show on the road and not adjourn. I'm not asking for special treatment, but it's only that if she feels particularly tired and wants a break, she may have breaks in a way that perhaps a quote-unquote normal witness may not. But
yes, okay, all right, well, thank you. Are you feeling well enough, Ms. Greengrass, to continue?
Yes, just forgive me if I start coughing.
Right, okay, well, if at any time you do need a break, then just let me know and we'll of course do that.
Thank you.
Okay, Mr. Banner, then when you're ready, please.
Thank you, sir. Ms. Greengrass, could you please take up core document 2.4, which is the local plan?
Sorry, the local plan.
It's 3.1, I do apologize, 3.1. It's in the same folder.
Sorry, is it the local plan, did you say?
Local plan, that's right, CD 3.1. And when you've got it, go to page 23, policy growth 1.
Yes, I've got that.
I'm going to the first series of questions relate to the issue of most important policies. I'm just going to focus on the main issues because there's been a big debate in the written evidence between you and Mr. Hill. I don't want to rehearse all of that. But within policy growth 1, we see the housing requirement adopted in the local plan set out there, and the council's position now is that that policy and the requirement it sets out is out of date. That's common ground, isn't it?
Yes, that's right.
And when we turn to growth 2, which starts on page 25 of the plan,
Yes.
Growth 2 has been characterised as setting out the locational strategy for delivery of the adopted requirement in Growth 1, and that's a fair characterisation of Growth 2, isn't it?
Yes.
Yeah. So it's a strategy for the delivery of an out-of-date housing requirement. We can agree that too, can't we?
I think it's a strategy that delivers where the housing in the district will be located.
Well, where the housing required by Growth 1, so we agreed a moment ago, it's the locational strategy for the delivery of the adopted housing requirement. We agreed that, and that's correct, isn't it?
Yes.
So therefore must follow, if you listen to the word in question, must follow. It's a strategy for the delivery of an out-of-date housing requirement, is it not?
When that policy was written, yes, it would have been related to policy growth 1.
Well, it's not been changed since it was written, has it? It's the same policy now as the one when it was written.
Yes.
So I'm struggling to see why you're finding it so hard to agree with me. and Miss Greengrass, it's a strategy for delivery, a locational strategy for the delivery of an out-of-date requirement. That's correct, isn't it?
Yes.
And let's be fair, Miss Greengrass, a strategy for delivering an out-of-date requirement is an out-of-date strategy, isn't it?
No.
But why on earth not?
Because the strategy would be the same, even if the numbers in growth 1 were different. You would still have the same locational strategy. You'd be directing development to the most sustainable places and controlling development in the countryside, which is what growth 2 does.
How can you be so sure about that until the new requirement has been tested? That's a guess, because you don't know what the effect on the strategy will be until the out-of-date requirement that it seeks to execute is itself replaced by a independently tested new requirement. That's right, isn't it?
You can't assume, on the other hand, that the same strategy would still work even if the figure changed, because you'd still want to put development in the most sustainable places.
Yeah, but how much development and where the needs are and what particular types of needs are, those are all matters which relate to the overall requirement, which is out of date. Yes?
The requirement's out of date, but I think the strategy is in line with the MPPF. It's not, the strategy itself is not an out of date strategy.
Would you agree this with me then, at least, that it would be wrong to make assumptions about what the new housing requirement will be in this context, because that new requirement has not yet been tested independently by examination, having regard to the various points made by consultation respondees? Would you agree that?
Yeah, I'd agree it's not been tested, but also...
That wasn't what I asked you to agree. I asked you if it would be wrong to assume what the new requirement will or won't be.
Yes, we don't know what the new requirement's going to be as yet. We don't know the tested requirement.
Thank you. Now, could you please keep the local plan open, because we're going to come back to that in a different context in a moment. But if possible, could you please take up the Statement of Common Ground? That's core document 4.4. And also your proof.
Sorry, Statement of Common Ground for who? For
Planning one.
Sorry, the plan.
The planning one.
Yes, I've got that here, yes.
And could you take out your proof? So it's the in the Statement of Common Planning Statement of Common Ground, it's section 4. And your proof, paragraph 5.4. And this relates to the basket of most important policies. In the Statement of Common Ground, there is a list of what are agreed to be relevant policies set out there, and we see that list. Then in your proof at 5.4, you set out what you consider are the most important policies, the purposes of the framework.
Yes.
And you, I think you said in relation to growth 4, having said in your proof that you thought it was not relevant, you think you refined your position in your evidence in chief, so you accepted it was relevant, but you thought it wasn't decisive or determinative, and that's why it wasn't a most important policy. Do you recall that?
Yes.
So what I'm just trying to understand, Miss Greengrass, is what principle or approach you have applied in working out which of the relevant policies are most important policies, because you treat those as different categories. There's a broader category of relevant policies, and of those, some of them are most important. They're not one and the same in your view. That's right, isn't it?
Yes.
And as I understood what you said in chief, the litmus test that you have applied, illustrated by your approach to policy G growth 4, the litmus test is, are they decisive or determinative? That's what you use to filter out growth 4, isn't it?
Yes.
So is that the approach you took to the other various policies that Mr. Hill includes in the basket and you exclude from the basket? You adopt the same approach you did with growth 4. The question to your mind is, are they decisive or determinative policies? Yes?
Yes, yes.
Could you just tell me where in the framework, paragraph 11, do we see that test as the, if you like, the gateway to something being a most important policy, that it has to be decisive or determinative? Where do we find that test that you've applied, that filter? Where do we find that in the framework?
Yeah, there's nothing in the framework that gives you a test or a bar. It's a matter of planning judgment.
Right. Well, it's planning judgment applying the right test. We can't say everything's planning judgment, Ms. Greengrass, can we? We have to all apply the right principles and approach and apply our judgment in that context, don't we?
Yes.
And the principle you've applied is that the filter to ascertain which of the relevant policies are most important is, are they decisive or determinative? I think we've agreed that's not a filter we find in the framework. Is it a filter we find in any appeal decisions you can point us to? A test or approach that any inspector you're aware of, whether in East Cambridge or anywhere else, has applied the decisive determinative filter to ascertain which are the most important policies? Can you point to any appeal decision, Ms. Greengrass?
No.
What about any court cases? Can you point to any court cases that apply that same filter that you do?
No. No.
So it's an approach that you've made up yourself.
It's my own professional planning judgment.
If the inspector considers you've applied the wrong filter, that approach is not supported, then the only evidence before him that has applied the correct approach is that of Mr. Hill, isn't it?
Well, the inspector is at liberty to use his own judgment to decide which policies he feels are most important.
Question I asked. I'm talking about the evidence before him. Be fair to me, Ms. Greengrass. If you've applied the wrong filter, too narrow a filter, decisive or determinative, that means that of the two experts giving evidence to the inspector, the only one that's applied the correct approach is Mr. Hill, isn't it?
Not necessarily. Has he applied the correct approach?
Well, have you said that he hasn't?
No.
No. Thank you. I'm now going to move on from the subject of most important policies to look in a little bit more detail about growth 2. So put the planning statement of common ground back to one side. We will need to come back to it later. And I'd like to go back to the policy growth 2 on pages 25 and 26 of the local plan.
Okay, I'm there.
In the 4th paragraph of growth 2, there's a sentence beginning outside defined development envelopes. Do you see that paragraph?
Yes, yes.
It tells that outside defined development envelopes, development will be strictly controlled. Then it says this: having regard to the need to protect the countryside and the setting of towns and villages. And those words I've just emphasised, having regard to the need to protect the countryside and the setting of towns and villages, those are the words I just want to focus on for a moment. And what they tell us, Ms. Greengrass, do they not? It is that the rationale for the strict control outside development envelopes, the rationale, the purpose of that strict control is founded on the need to protect the countryside and the setting of towns and villages. That's right, isn't it?
I think that's part of it, but it's also, the policy is also trying to locate development in the right places in the first place.
What do you mean by that?
Well, the policy is a locational strategy, so it starts with this is where we wish to see development placed.
Yes.
And then the second part is having regard to anything outside, having development with control, having regard to that what you just said, yeah.
Yeah, and I'm looking at the strict control element, because there's various, growth 2 has a number of different elements, and the strict control element is the one I'm just exploring with you now, and that's the one I just read out. And it tells us, does it not? It tells us in express terms what the main considerations are, which form the rationale or the purpose of that strict control. And those main considerations are having regard to the need to protect the countryside and setting of towns and villages. Those are either the or the main purposes of the strict control referred to, aren't they?
It's part of it, but it's also to prevent. The strict control is a strict control by only allowing certain types of development in the countryside, which are listed below the exceptions.
And then that begs the question, why though? Just understand this. I'm not talking about at the moment, I'm not talking about what the policy does or doesn't require. I'm talking about why, what's the purpose, what's the thinking behind the policy. That's what I'm trying to get to, Miss Greengrass. And I suggest to you, just say, take your time to think about this question if you need a moment, that we don't need to guess what the purpose of the strict control is, because we're told what it is, having regard to the need to protect the countryside and the setting of towns and villages. That is the purpose, the reason for the strict control, isn't it?
Yes.
Thank you. And if we go back to the supporting text on the previous page, page 24, that is the fact that the purpose of the strict control is protecting the countryside and setting of towns and villages. That's reiterated in the supporting text, the top of page 24. Let's just look at what we're told. Second full sentence on the page 24 in 3.3.4, it says this: the overall aim is to focus development within or on the edges of towns and villages and to minimise unnecessary development of open fields and countrysides. Then we're told the strategy is in accordance with the framework as then was, which states that local authorities should protect the intrinsic character of the countryside for its own sake. And I'll come on to that in a moment. And then it says this: development envelopes have therefore been drawn around the main built-up areas and villages. And then it says this: in order to prevent sprawl into the open countryside and protect the character and setting of settlements. And the words "in order to" are very clearly pointing to the purpose or the reason. They tell us why, don't they?
Yes.
And the reason why, once again, is to prevent sprawl into the open countryside and to protect the character and setting of settlements. So that's consistent with what I characterised before as the purpose of the strict control, isn't it? Being to protect character and setting of the settlements and to protect the countryside. Yeah?
Yes, yes.
And just in terms of the reference to protect the framework in protecting the intrinsic character of the countryside for its own sake. And the wording now in paragraph 174B of the framework, ever so slightly different. I'm not suggesting there's inconsistency here, but we obviously want to read it in light of the current framework. So just get that 174B so you can see what the framework says.
Yep.
It's on page 50 of the framework.
Mm-hmm. Yes, I got it.
And one of the things is recognizing, not protecting, recognizing the intrinsic character and beauty of the countryside. And I assume you would agree with me that we have to read growth 2 consistently with in a way that gives effect to the latest iteration of the framework in this respect, recognizing the intrinsic character and beauty of the countryside.
Yes.
Yeah. And would you agree with me, Miss Greengrass, with the following, that recognizing the intrinsic character and beauty of the countryside doesn't mean that you assume, without any further consideration, that all countryside has precisely the same qualities.
Yes, I'd agree with what you've said, yes.
Thank you. And that's, if I may say so, a very fair review, because it's correct, isn't it, that the extent to which any particular piece of countryside contributes to character and beauty, and the extent to which any particular development on it will impact upon that character and beauty, that's always going to vary from case to case, isn't it?
Yes, yes.
And I think it must follow, mustn't it, that where on analysis, doing that case-to-case analysis, where on analysis any particular development would not, in fact, have any significant impact on the character and beauty of the countryside, rare though whether that may be, but where there would be no significant impact on the character and beauty of the countryside, and where there'd be no impact on the setting of the town, the stated purpose of the countryside protection we just looked at isn't undermined in the same way that it would be if there would be significant impacts. You see what I mean? Imagine two kinds of developments. One that would have an impact on those considerations, and one which would have no significant impact on character and no significant impact on setting. The effect of those two developments on the purposes of the policy would be different, wouldn't they? Yeah.
Yes, because yeah.
The one I described that would have no significant impact on character and beauty and no impact on the setting of the town, that would not undermine the purpose of the strict control referred to in Growth 2. It may or may not breach Growth 2, that's a separate thing, but it wouldn't undermine the purpose of protecting the character of the countryside, protect against spawn, protecting the character and setting of settlements. It wouldn't undermine those purposes with it.
Yeah, I'd agree with that. Wouldn't undermine that purpose, yes.
And so if looking at Growth 2, a development falling to that kind of description, if it was outside the settlement boundary and didn't fall within the limited categories of development that were permissible, it would still conflict with the wording of Growth 2, but the extent of its conflict with the purpose of Growth 2 would be much more limited than a development which would have significant adverse impacts to those considerations, wouldn't it? The extent of conflict with the purpose would be much more limited, if any.
With that particular purpose of the policy,
yes. Yes, I mean, we've already discussed whether that is the purpose of strict control. Thank you. Now, you've not in your proof, I don't think, and please do correct me if I'm wrong, you've not given consideration to the extent to which the particular development in this case, on the particular site in this case, would conflict with the purpose of Growth 2. You've looked at whether it conflict with the letter of Growth 2, but I didn't see anywhere any assessment of the kind that we discussed in principle just now of, well, to what extent would this actually conflict with the purposes of the policy? If you think you have, please do show me where you have, but I didn't see it myself.
No, you're right. I haven't talked about the how can I put it, the harm, the visual landscape harm, because that wasn't an issue contested by the council. So I haven't talked about that in my evidence.
That's sort of my point, actually, if you don't mind me saying. Can we just have a look at that visual hut? So what I want to do is understand whether actually, now, if we do look at the extent to which the purpose of this strict control is or isn't undermined by the appeal scheme, I think we do need to look at this. So can I ask you to take two documents out? If you're a dinosaur like me and have the hard copies, I think they're in the same folder. So it's core document 1.42, which is the LVIA, and core document 2.1, which is your proof.
Hang on, I haven't got the LVIA, so what's that?
Could you take a moment to get it? CD 1.42.
1.42.
Yes. quite a long document, and the part that I'm keen to go to with you is on page 62 of the hard copy.
Okay, let me just try and find that.
Can I get the page reference again, Mr. Banner?
Yeah, 62 or 62 of the LVIA,
Yeah.
The officer report. It's paragraph 7.3.6 and 7.3, 736 and 737 on page 35.
Of what, sorry? The officer report, did you say?
Yes, so we need the LVIA and the officer report.
Oh, I thought you said my proof. Let me find that officer report.
Yes, you did actually, Mr. Banner. What's the CD reference to the officer report?
2.1, CD 2.1.
Thank you.
Sorry, if I said proof, I apologise. That's a slip on my part. Ms. Greengrass, let me know, take your time, let me know when you've got those available.
Sorry, I have a hard copy for here, and I have it somewhere. So I've got the officer report, and I've got the landscape impact, and I'm on page well,
If you get to page 62, it should say 13 conclusion.
62 says, oh no, page 62 mustn't tally with yours because it says construction stage.
Right. Can you go through, because at the very bottom of the page, on the actual text, there's a page 62, at the very bottom right-hand corner. You see, it says 62. It's paginated.
Yeah, I'm looking at the pages on the document, and 62 is what I just said, construction phase. Sorry, I'm not being very helpful here. And that's the pages as they're numbered on the screen.
That's well.
Are you looking at the LVIA, Ms. Greengrass?
I think so. Hang on.
Yeah, CD 1.42.
Let me just check. Sorry.
Do you have 62? Says yours the same as mine. Just to check, it's not me.
Right. So yes, it's the landscape visual impact assessment. That's it. Got the right documents. It's entitled Landscape Visual Impact Assessment. Yes.
It is, and it's section 13 conclusion that I'm after.
Okay. Let me look. It does say 63. You're right, but somehow, right, I'll try and find that. Nearly there, 12. Yes, 13 conclusion. Yes, got that.
Thank you. Brilliant. So let's start with landscape character, because obviously that's character is what's talked about in the references to the policy we looked at. And the construction stage is described 13.3. And it said in the last two sentences, the significance of landscape effect for construction is negligible. The assessment of landscape effect is not classified as significant. And then at the operational stage, 13.4 and 5, the headline conclusion is as a minor loss of key landscape evidence, but not introduction as common and uncharacteristic. The subsequent landscape effects are considered not significant in planning terms, having regard to mitigation. Residual significance of landscape effects. The development is considered to have no significant residual effects on character. So just pausing there and going to the officer report. And I'm right in thinking you wrote the officer report, did you, Ms. Greengrass, yourself?
Yeah, yes.
So you say at 7.3.6, having referenced the rest of it, the recognition of intrinsic character with the countryside, you reference the LVIA, you quote passages from it, and at 7.3.7 you refer to the conclusion I just read out, in fact. Not uncharacteristic when set in within the attributes of receiving landscape. And then over the page, the top of page 36, assessment landscape character, which has low sensitivity and magnitude change small, the significance effect is negligible. So pausing there, in terms of landscape character, in your report, you effectively accepted the findings of the LVIA, didn't you? You didn't say, well, actually, they've understated the position. You referenced what the LVIA found, and you agreed with it in relation to landscape character.
Yes.
Yes. So the common position between the council and the appellant is, in terms of the effect of development on character, there were literally no significant effects at all. And in terms of visual impact, we can just go straight to the office report 739. You say that visual impact is considered acceptable. That's in the final sentence of 7.3.9.
Yes. Yes. Yeah.
So thank you. We can put the LVIA away. And can we then go back once again to policy G, I keep calling it G2, growth 2, core document 3.1, page 25.
Yes, I've got that.
And when we consider the stated purpose, the protection of the countryside, recognizing that character of the countryside will vary from piece to piece, and recognizing that protecting the setting of towns and villages. And then we go back to that passage we saw in the supporting text, preventing sprawl, protecting character and setting. Having regard to the particular circumstances of this site and this development, there is no, the agreed position I've set out in the LVIA, there is no harm to those considerations from this development, is there? I accept there's a conflict with Road 2 because we're the wrong side of the line of the plan, but those purposes, why countryside is protecting character, preventing sprawl, protecting setting of settlements, we can agree that there is no harm to those purposes which were the reason for the strict control. We can agree that, can't we?
Not entirely. If I can just qualify what I mean.
Yeah.
I agree with you that in my officer report, I didn't consider there was a degree of landscape impact that would warrant a reason for refusal, that would warrant a respectable reason for refusal in terms of landscape harm. But at the same time, one has to accept that by building houses on what is a greenfield site must give rise to some element of harm. It's still sprawl, it's still development on a site which was otherwise open on greenfield. So whilst I accept there wasn't significant visual harm, landscape harm, at the same time there is still some harm because there is still some sprawl into what is countryside. So that's
that often it is the case that the professional findings in LVIA is such that there is harm by virtue of the mere built on land. But the LVI here with which you agreed and which you continued said, well, actually, in the circumstances here, due to the nature of the site, due to the fact that it's there's development nearby, development is an uncharacteristic of the area, due to the mitigation, applying the GLIVIA guidelines, not applying anything else, applying the same guidelines, the finding which you agreed with was no significant residential effects, not significant in planning terms. It wasn't simply that there's harm, but it's unacceptable harm. You sometimes find that. That wasn't the position here. It was not significant in planning terms, not just enough to justify a refusal, but didn't even go on the radar. We can go back to that page if you can find it again, if you want to double check that, page 62 of the landscape and visual impact assessment. Not significant in planning terms. It doesn't feature on the radar in planning terms because it is so insignificant. That's what the report is telling us, and you agreed with it in your own.
It does say not significant in planning terms, but doesn't mean to say there's no harm at all, does it? Doesn't mean to say there's
no meaningful harm. Okay, no harm. Would you? Okay, let me rephrase the question then. in terms of considering the stated purposes of growth too, there is no significant in planning terms harm to those stated purposes, is there? That's the common position of the country. No significant in planning terms harm to those considerations. Do you agree that?
Yeah.
Thank you. No significant planning terms harm to the purposes of that strict control. Thank you. Now, you made some various points in the chief about sustainable patterns of development. Sometimes that's thought to inform countryside protection policy too. So I just want to make absolutely sure we're on the same page in relation to sustainability. Can I ask you to take up two documents, the Statement of Common Ground, the main one, which is core document 4.4, and also Mr. Parfitt's proof, which is core document 5.2.
Sorry, what am I? Sorry, give me a minute. What am I getting now? Oh, Statement of Common Ground. Did you say yes?
Yeah, Statement of Common Ground, which is 4.4.
Yes.
And Mr. Parfitt's proof, which is I think 5.2. You may have it separately.
Remind me, Mr. Parfitt is which one is he? Is he the landscape one?
No, he's the highways one.
Highways one.
It's not called up. Sorry, it's just his proof. Sorry.
Oh yes, yeah, I've got that. Mr. Parfitt, requirements of transport. Yes.
So, Statement of Common Ground 4.4, paragraph 6. Bear with me one moment.
Sorry, Mr. I get the reference, that paragraph 6 in the
areas of agreement of the Statement of Common Ground. So it's actually not paginated the Statement of Common Ground, but it's section 7, and there's a list of areas of agreement, and there is a reference to locational factors, and there's a paragraph 6 there. And this is a Statement of Common Ground which I think you signed, and it says the application site is sustainably located in close proximity to and accessible from a range of local services, facilities, and employment. Yeah.
Yes, I've got that. Yes.
And you don't rescind from that agreement, do you?
No.
And if we go to Mr. Parfitt's proof, page 14 is entitled Accessibility. And he, from the perspective of somebody with expertise here, explains why in his professional judgment the appeal scheme is sustainably located as summarised in the Statement of Common Ground, and there's no challenge by the council to what he says at section 8 of this document, is there? There's been no challenge, has there?
No, there hasn't.
No.
Are you referring back to the point I made earlier? The point I was trying to make was that it's just tempered by the fact that we don't know that everyone is going to walk, cycle.
You never do. You don't, even if you live in the centre of London, Miss Greengrass, do you?
No.
So can we agree this, that insofar as part of the rationale for growth 2 is about sustainable patterns of development, insofar as that is part of the rationale for growth 2, there is no significant in planning terms conflict with that rationale generated by this appeal scheme, because it's a sustainable development in a sustainable location. We can agree that, can't we, in light of what we just looked at?
Yes, I'd say it's certainly a sustainable location, being on the edge of Soham, which is one of the main towns in the district. I suppose in terms of sustainability, what I was trying to say earlier is that because it's at the edge of the town, it's perhaps less sustainable than something which would be closer to those facilities. So sustainability, it's not a binary thing. There's a spectrum. Is how sustainable?
Can we stick to the question? Can we stick to the question I asked? So there is no significant in planning terms harm to the principle of promoting sustainable patterns of development caused by the scheme.
No.
Thank you. Thank you. I now want to move on to a separate but related subject of accordance with the plan as a whole. So for this, we're going to need core document 6.1. And that is a judgment of the Court of Appeal in a case called Corbett and Cornwall. Do you have that?
Yes, I've got that now. Yes, I've got that.
Thank you. So I just want to put this into context first of all. So if you've got the first page, judgment of Lord Justice Lindblom. This was a judicial review challenge to a grant of a planning permission by Cornwall Council for a tourism-related development. We see the main issue in the appeal summarised in paragraph 1 of the judgment, that Cornwall Council granted permission for development that was in conflict with development plan policies for areas of great landscape value, but it was compliant with other policies, including one encouraging tourism development. And the council took the view that, notwithstanding the conflict with one policy, it was in accordance with the plan as a whole, and the judicial review challenge was to that approach. Yes?
Yeah.
Then, and just for the flesh, we just then turn over the page. At paragraph 7, we see policy 5, which is a policy relating to tourism that says tourism is a good thing, etc., in terms set out in policy 5, quoted section 7. Then at paragraph 10, we see the AGLV policy and the requirement to maintain the character and distinctive. The last sentence in the quote at paragraph 10, maintain the character and distinctive landscape qualities of such areas. And this was a tourism facility which was supported by one, but it caused a degree of minor harm to AGLV, so it's conflicting with policy 23. If you want to see that, you see that at paragraph 13 of the judgment, where the officer report notes that there's a slight moderate impact on AGLV, but one which nonetheless triggered conflict with policy 23. That's by way of context. I then want to go, if I may, to paragraph 27 of the judgment, a few pages in, please.
And can I take you back? Just let me read paragraph 13 a minute, please.
Yeah, take your time. It's not really relevant to the principle. Just put some context on the factual context of that, because there's references to the facts later on.
Okay, yeah, I've read 13. So now we're going to 27, did you say?
27.
Okay. Does that begin with of the 5 points, that one?
Yes, that's right. And the section that follows from here is looking at some of the principles, and obviously Mr. Smythe and I will in due course discuss those principles in closing. I'm going to ask you about how you applied the principles in a moment. And 28, the court refers to a previous case called Milton, where Lord Justice Sullivan noted that development plan policies can pull in different directions, and therefore, over the page, reference to an earlier judgment, the overall task is consider whether development does or doesn't accord with the development plan as a whole. There may be some points in the plan which supports the proposal, maybe some considerations pointing in the direction. The decision maker has to assess all of these and decide whether, in light of the whole plan, the proposal does or doesn't accord with the plan. And then paragraph 51 of the quote from the Milton judgment, which is endorsed by the Court of Appeal in the Cornwall case. You say 51 is the paragraph saying, I accept that. Do you see?
Yes, yes.
So accept that the terms of the policy, however firmly it favours or sets its face against its relevant factor. And then it goes to say this: so too the relevant importance of the policy to the overall objectives of the development plan. And then this, and the extent of the breach. These are matters of judgment. And the court, they went on to say that, and the circumstance of the present case, Cornwall haven't got it wrong. And so it's clear, isn't it, from what this is saying, that one of the factors in considering whether a individual policy conflict leads to non-accordance with the plan as a whole, one of the factors is the extent of the breach. How serious or how significant a breach of the policy is it? Do you see that?
Yes, yes.
And it's right that it follows, therefore, that when you have a conflict with a policy of the nature of growth 2, which is a blanket approach to protection outside the development envelope in relation to development of this nature for the purposes set out, one doesn't take a one-size-fits-all approach. So, well, because there is a conflict, every conflict is as bad as each other, every conflict has the highest weight, and that leads to certain conclusions. You have to consider the extent of the breach. How serious is the conflict in the particular circumstances of the case, don't you?
Yes.
And in doing that exercise, in assessing the extent of the conflict by asking how serious is the conflict in the particular circumstance of the case, a very important consideration will be how big a conflict is there with the purposes of the policy, not just the letter, but the purposes. That will be a very important consideration, won't it?
Yes.
Now, if we just bear that in mind and go to your proof, 8.3 and 8.4 as the final to planning balance overall conclusion section. I don't mean to cherry pick particular parts of proof on this issue. They're all of the same vein. By all means, refer me to any other parts you'd like, but you don't consider these issues, do you, Ms. Green? Because what you do is you refer at 8.2 to the statutory test that we're all familiar with under section 38.6. You say that the proposal is contrary to growth 2 in terms of it being in conflict with the letter of the policy, and we accept that. And you said, therefore, say, I then consider whether there are any 8.4 material considerations which should indicate the development plan should be set aside. And nowhere do we see that interim or middle step of saying, well, there's a conflict with growth 2. I'm now going to turn to whether or not that conflict leads to non-accordance with the plan as a whole. And in doing so, I'm going to examine the extent of the breach, how serious is the conflict in the particular circumstances, and in that context, look at the very important consideration of how big a conflict is there, if any, with the purposes of the policy. You don't do that exercise in your proof, do you, Ms. Greengrass?
Not explicitly like that, no.
No, well, not implicitly either, do you? I mean, no, not at all, in fact.
I don't think so, no.
And we have agreed, I think, it's very clear that that is something that we can jointly recommend the inspector. He will need to do in his assessment, won't he? In light of that case law we've looked at.
Yes.
And in considering the question of compliance with, or accordance with plan as a whole, there are a couple of other considerations I'd like to suggest to you are relevant, and I'd like to see whether you agree whether they are or aren't relevant. Would you agree with me that in considering whether there's accordance with the plan as a whole, it is relevant that growth 2 is the only policy in which the local authority alleged conflict. That's not determinative, but it's a relevant factor. It's the only one in relation to which there's alleged conflict in the whole development plan.
Yes.
It's also relevant, isn't it, that in all other respects, the development is consistent with and or supported by the development plan.
Yes.
And it's also relevant to consider the extent to which the conflict with the growth 2 policy reflects real on the ground significant in planning terms harms. You know, is it a theoretical, is it a breach of a policy harm, or does it reflect actual real on the ground significant in planning terms harms? That's relevant to considering according to the plan as a whole, isn't it?
Yes.
Thank you. And it would be, being fair, it would be having regard to those considerations and having regard to the lack of conflict, the purposes of growth 2. You may or may not agree with it, but it would be within the range of reasonable planning judgments, wouldn't it, for the inspector to conclude here, applying the approach in Cornwall, that despite the conflict with growth 2, there is still accordance to the plan as a whole. That would be a legitimate and reasonable approach for him to take, wouldn't it?
No, because...
Really?
Yeah, because I say that because, like I've said before, growth 2 is the core thing. If you're conflicting with growth 2, you're conflicting with the plan as a whole, because it's growth 2 that sets the locational strategy for the whole plan.
Yeah, the difficulty with that, though, is if we look at that judgment again, it's contrary to what the judgment says, isn't it? Because the judgment says that that's one of the factors, but it's not the only factor. You have to look also at the extent of the breach. Just look at the judgment again at paragraph 51, the quote from Mr. Justice Sullivan, who then was.
I know it talks about the extent of the breach.
Can we just if you would do me a favour, just look at the paragraph, if you don't mind again. Paragraph 51. Lord Justice Sullivan considers there are 3 relevant factors. And the relative importance of the policy to the overall objectives of the plan is a relevant factor. It's not a knockout factor. It's not something, well, if it's a very important policy, you don't go on to consider the extent of the breach. It's one of the factors to be considered in the ground, and you have to also consider the extent of the breach. We discussed the extent of the breach.
Sorry, which paragraph? Which paragraph?
Paragraph. So it's Corbett and Cornwall. It's within Corbett and Cornwall. It's paragraph 28. That paragraph quotes an earlier judgment, and it's paragraph 51 of that earlier judgment.
Yes, I've got that.
That's Mr. Justice Sullivan, as he then was, and he goes on, he's providing guidance on how you go about considering accordance to the plan as a whole. And there's one is the terms of the policy, 2 is the relative importance of the policy to the overall objectives of the plan, which is your point, and 3 is the extent of the breach. And the point is you have regard to all of them. And what you're doing, Ms. Green, by saying that the inspector, very boldly saying it would be outside the range of reasonable responses, it'd be illegal for him to consider that there's accordance to the plan as a whole, you're placing decisive weight on the second consideration, relative importance to the policy to the overall objectives of the development plan, aren't you? That's what you're doing. You're saying that's the be all and end all.
Sorry, I'd really need time to analyse this paragraph, but this was a different.
It's planning 101, Ms. Greengrass. It goes to the heart of the statutory test.
I'm not really sure. Yeah, I'm not really sure. I mean,
if you can't answer, you can't answer. I'm sure you've got the point. I can move on. I can make today with that as submissions. I'll give you one more chance to provide any evidence you'd like, Ms. Greengrass, on this, and then we can move on.
You see, I think I don't know if I'm missing the point here, but the decision that was being made there was whether a campsite. I think I'm right in saying whether a campsite was acceptable.
No, that wasn't the Milton case. This is talking about the print. Cornwall's facts about campsite, but the principles, the court endorsed the Milton case, and the Milton case was looking not about the facts, looking at the principles. And the simple point is that paragraph 51 of the Milton case, endorsed by the Court of Appeal in Cornwall, said that there are 3 considerations which need to be looked at, each individually, each are relevant in considering the plan as a whole: the terms of the policy, the relative importance of the policy to the plan, and the extent of the breach. And they all need to be considered. And we've discussed the extent of the breach already, and I don't need to go back over that. What you're doing is saying, irrespective of the extent of the breach, irrespective of that, the inspector has to find non-accordance to the plan as a whole because of the relative importance of growth to.
I'm sorry for interrupting. Sorry for interrupting. So you were very strict with me and you refused to let me call evidence which wasn't in the proof. This whole point about it being just breaching the letter of growth to and not the purpose isn't raised in Mr. Hill's proof. I can find passing reference at paragraph 5.1.12, but my learned friend is making a great deal out of a point which was not raised in the proof.
Squarely.
Okay. Let me just say then, I think this is a legal point anyway, which is probably best dealt with it for submission.
As I said, I'm happy to move on. So I've given the witness an opportunity to consider the points, and she said what she said. I want to now, Ms. Greenglass, talk a little bit about the benefits and weight in light of the information which largely appears to be agreed. And so first, in relation to the provision of market housing, we can agree, can't we, Ms. Greengrass, that even if there is a 5-year supply, a 5-year supply is a minimum, not a maximum, obviously. If you said yes, I didn't hear you, Ms. Greengrass, I'm sorry.
Sorry, what? Sorry, repeat the question. Sorry,
yes,
I wasn't.
The existence of a 5-year supply is a minimum, not a maximum.
Yes.
And it doesn't mean that the provision, that the contribution a development make to the supply of housing isn't a significant benefit. It doesn't mean that if there is a 5-year supply, does it? It doesn't deprive the contribution to housing supply. It doesn't deprive it of being a significant benefit.
Well, my evidence says that I consider it to be a moderate benefit of moderate weight because we have a 5-year housing supply.
Yeah. Well, I'm asking you to consider that. So your view is that you can never give significant weight to 5 years to the contribution of development make to housing supply where there is a 5-year housing land supply.
No, that's not what my proof says. My proof says a moderate weight.
Okay. So can you try and answer my questions, Ms. Greengrass, rather than answer different ones then? Paragraph 60 of the framework tells us that the framework always has a need to significantly boost the supply of housing. That's right, isn't it?
Yes.
And doing the bare minimum of having a 5-year supply is not significantly boosting the supply of housing, is it? Doing the bare minimum and then stopping there is not significantly boosting, is it?
Well, maybe not, but the government only requires a 5-year land supply, so we're meeting the government's requirements.
Yes, but we're looking at whether what weight one gives to 5 years to the contribution of development made to housing in that situation. And saying that, well, we've got 5 years, we don't need any more, thank you very much, so we're not going to give significant weight to that. That is not an approach which seeks significantly to boost the supply of housing, is it?
Well, I
just answer the question first and then qualify it, Ms. Greengrass. You're slipping into giving non-answers. So if you could answer the question and then give whatever caveat or qualification you'd like. Grateful.
What was the question? You're saying if we have a 5-year housing land,
then I'll only have to say it once. An approach which says we have a 5-year supply, and now that we have a 5-year supply, we're not going to give significant weight to the contribution of development make to housing. That is an approach which does not strive significantly to boost the supply of housing, is it?
I suppose you can always have more housing. Yes, I suppose, yeah. You can always have more housing above the 5-year supply.
The local plan housing requirement is still part of the statutory development plan, isn't it?
Yes.
It was based on an objective assessment of housing need that was tested independently examination.
Yes.
existence of a 5-year supply in the district, where previously, some couple of years ago, there wasn't, is largely a result of the standard method coming into application in the district for the purposes of 5-year supply, writing off the shortfall and reducing the number. Largely, that's why the council has gone from a shortfall to a claimed surplus.
Yeah, I think so.
But even if that is, even if the council does have a 5-year supply now, which obviously we don't accept, even if it does, the past shortfall in delivering the statutory plan requirement is still a material consideration in planning terms. It's still relevant, isn't it?
No, because if we're meeting our requirements, we've got a 5-year supply plus, then we're over and above what we're already, if we're already plus 5 years, we're already meeting above what we're required to meet.
So can I understand in terms of the way you've approached weight in this, and I can make some, so your approach, leaving aside calculation of 5-year supply, in terms of the weight in the planning balance to be given to the provision of market housing, your approach is that the shortfall against the still adopted local local plan requirement is of no relevance whatsoever to the inspector's judgment. That's your approach, is it?
You mean the past shortfall? Is that what you mean?
Past and future, because Mr. Cumming, Austin Fells made very clear there's an existing shortfall and it's only going to get worse against the local plan requirement. So both. See section 11 of his proof. And I'm simply asking you, are you accepting that it's relevant, or do you take an approach to weight that assumes it's irrelevant? Which of the two is it?
I don't know, because I'm giving some consideration to the council's single issue review, which is giving a steer as to how things are going in the future, and how things are going in the future. There's not going to be a requirement for masses of more housing.
I thought we agreed at the beginning that we can't guess what the single issue review is going to say, because there will doubtless be objections to it. People will say, actually, it doesn't have regard properly to affordable housing, to real needs. There should be an uplift from the standard method. There's all sorts of things that have to be tested in independent examination. We can't prejudge the outcome of that. I thought we had agreed that at the beginning of this cross-examination. Did we?
I said it hadn't been tested, but I still give some regard to the council's position. I'm not going to ignore that, and I think the inspector can as well.
So should we get back to my question then? What do we do right now in a situation where we've got an still adopted local plan requirement, which may not be the figure for the purpose of testing 5-year supply, but still an adopted requirement? There's an existing shortfall against it, and there's going to be a future shortfall against it. In judging how much weight to be given to the housing supply contribution to the scheme, do we ignore that fact altogether and put it out of our minds, or do we take it into account as a relevant consideration?
I think we can ignore that.
Ignore it. Okay, we ignore the development plan. Very well. Affordable housing. I want to just explore the facts, which then inform a judgment as to weight. So we need Mr. Stacey's proof for that. Also, I'm not going to debate the facts with you because the facts appear to be agreed, but I want to explore what are the main facts which inform a judgment as to weight. And I think we can go to principally Mr. Stacey's summary, beginning of his proof, the third page. We see key findings. And Roman numerals is number 14. If you have that before you.
Well, can I get the reference again, Mr. Banner? Sorry.
Yes, Mr. Stacey's proof, the executive summary at the front, and it's Roman numeral 14 or X1V under key findings. Let me know when you have that. Do you have that now?
Yes, I've got that, yes.
Okay. And he says in the first bullet that the 2013 SHMA, which was tested in the local plan examination, came up with an annualized figure of 176 affordable dwellings. We see that figure at the end of the first bullet, 176. Do at any stage, if I've got anything wrong, let me know. Otherwise, I'll just trot through this.
Okay.
Then there were two 2016 reports. He tells us about the second bullet, and they indicated a annual need of 130 per annum from 2016. And then he notes the fourth bullet that the 2016 assessments were never tested. So his view is that the tested figure in the SHMA of 176 is the most appropriate figure to use. No one said he's got that wrong. Then in terms of delivery, give me one moment. Yeah, in terms of delivery, the 13% of overall housing between 2011 and 2019-20 was affordable. 13% compared to the plan requirement of 30 in this area. Then over the page, that meant that in numerical terms, there is a shortfall so far of 1,205 from the 2013 SHMA figure, which, as I say, Mr. Stacey, uncontested, says is the appropriate tested figure to use. So 1,205. Even against the lower 2016 report, he says the shortfall since 2016 will be over 500, 505. And then what he then does is say in the third bullet under future delivery that if one wanted to make up that backlog, then applying that 1,205 shortfall from the 2013 SHMA, there would be a need for 417 affordable homes per year in the next 5 years, if one is to make up that backlog within 5 years. And then 2 bullets down, at the time, this has changed a bit in light of some of Mr. Kay's concessions, but based upon the council's claimed 5-year housing land supply at the time when this proof was written, the component of the council's claimed 5-year supply that was affordable housing is 895. It's a bit less now. Mr. Stacey will update that in light of the concessions today. I think it's about 850 now, but 895. And then 2 more bullets down, when you take into account losses to right to buy, as Mr. Stacey in his unchallenged judgment thinks it's appropriate, that works out as a future supply over the next 5 years of 176 affordable homes per annum, against the need, in order to make up the shortfall whilst dealing with existing needs too, against a need of 417. So what he's saying is, therefore, and again, none of this is challenged, is that on the local authority's own supply figures, based upon the extent of need, the position is that in the next 5 years, the local authority won't even come halfway close to making up the shortfall, which is currently over 1,200 people. Now, all of those uncontested facts, Miss Greengrass, all of those are relevant to the weight to be given to the affordable housing contribution that the appeal scheme will make, aren't they?
It's not denied there's a shortfall, so.
Can you answer the question, please?
Potentially, yes.
Only potentially. Only potentially relevant that there's 1,200 people who are in need of an affordable home in this area who haven't had one because of the undersupply, and the council isn't going to do half of what's needed to make that shortfall up in the next 5 years. And you said it's only potentially relevant?
Okay,
Just reflect on that.
It's relevant.
It's highly relevant, isn't it? And powerful, would you not? suggest, a powerful factor in favour of allowing these affordable homes?
I wouldn't say you need to allow this development site just so that we can get some more affordable housing. It doesn't make the whole site acceptable just so we can get affordable housing. I mean, if this was a site for 100% affordable housing, then there might be a case to be made. But we've already got sufficient supply of housing land. I can't see a reason why.
That's the point. You don't.
Just so that we can get some additional affordable housing provided.
Ms. Greengrass, would you accept this, that it's clear from what Mr. Stacey says, both here and elsewhere, that if all the authority does is to allow development which is completely in accordance with every policy in the local plan, it will not come close to meeting the identified affordable housing needs? It must follow from what Mr. Stacey says, mustn't it? That
yes, yeah, that would follow.
Won't come close, won't come halfway to meeting identified needs if all it does is require strict adherence in every case with the local plan. That's right, isn't it?
That's right.
It must then follow, mustn't it, that if a serious attempt is to be made to try and come close to meeting affordable housing needs, consideration needs to be given as to appropriate relaxations to strict adherence with the local plan, appropriate relaxations in cases where particularly the balance of and harm and impact and benefit is such that there's very limited harm and a lot of benefit. Would you agree with that?
No, because that would be perverse, because that would be like saying, oh, let's allow lots of housing development outside of the development boundary just so we can get some affordable housing. I mean, well, that's the converse of what, surely that's the converse of what you're saying. You're saying we should allow this appeal so we can get this much needed affordable housing. Are you not?
Did I say that, Ms. Greengrass? Did I say that?
Repeat what you said.
Did you answer my question? Did I say that?
I don't know, because I can't remember what you said now.
Perhaps try listening to what I said, and then we can try and have a proper debate. Doesn't this colossal shortfall and lack of any prospect of being made back through strict plan adherence suggest that a more nuanced approach, just don't allow everything, we don't allow nothing that's not in conflict, a more nuanced approach to how the council looks for development? Do you comply with every single policy? A more nuanced approach than you're applying is required, is it not?
No.
Right, okay. Very well. Can we now go to your officer report, paragraph 8.1? And in your office report 8.1, you note, don't you, that the original 30% proposal of affordable housing at the time of the application was in excess of the level of provision recommended in the council's viability assessment report for Soham, because the viability assessment, which the council still treats as of ongoing relevance, suggests a starting point of 20% in Soham, doesn't it? That's right.
That's right. That suggests that can be relevant for Soham, yes.
And the council treats that report as of ongoing relevance, doesn't it?
Yes, it's still relevant, yes.
I mean, for example, there's an application currently in by Vistry, isn't there, which you're the case officer for, and they're proposing 20%. And in light of that report, you've not pushed back in relation to that, have you?
No, because the situation is that if a developer comes forward and says that that's all they can provide, this document allows for the fact that we don't have to go and get an independent valuer's assessment. This document is saying, actually, if you're telling us that, then that's relevant. We don't have to get an independent valuer's assessment of that.
You don't require viability assessment. If a developer says 20% is all we can do, you don't require any justification of that, because you take the previous viability assessment report as an adequate justification for 20% around Soham.
Yes.
Yeah. So what's proposed by this scheme, so in terms of amount first, 36%, 10%, 16% above, if you like, the norm that's coming forward in some other sites and so on, and 6% above the policy requirement. It would be fair to characterise that as unusual as a percentage, an amount in quantitative terms, an unusual proportion of affordable housing for market-led scheme and so on.
No, because 30% is policy compliant. Obviously, this appeal site feels that 30% is viable for their scheme. If they didn't, they wouldn't be proposing it.
Can you, again, try and listen to it? I said unusual. If you say it's not unusual, so therefore it must be usual. So can you point me to any other schemes in the, say, last couple of years in or around Soham which have promoted 36% affordable housing or higher?
There haven't been many, because most of the sites, because of, as evidenced by this report, most of the sites have found it hard to reach viability.
Yeah, so it is unusual, isn't it? This amount of affordable housing for market-led scheme is unusual.
Maybe, it may be today, but that doesn't mean to say it wasn't in the past. Right. Things move all the time in viability.
And it's unusual in its diversity of offer, isn't it? Because it's actually covering for a number of rented, intermediate, first homes, custom self-build and market. It's covering a number of different categories of people in need. And that range, that breadth of offer is also something that's unusual.
I wouldn't say that's unusual. The only thing that's perhaps a bit different is the fact that this developer has offered 10 first homes, which is different because it's the first one we've had offered of first homes. So that's different, but everything else is just usual.
Right, we'll come on to other custom self-business in a moment, but first homes, first one we had, so it's actually not just unusual in relation to first homes, but unprecedented in relation to the provision of first homes.
Unprecedented. I wouldn't say countrywide. It's certainly the first one that I've come across, and so on.
Yeah. And the reason first homes are recognised in government policy as a form of affordable housing is because they do meet a particular element of need that other categories of affordable housing don't they? Yes,
and of course it'll become less unusual because of the new government legislation on provision of first homes, so it will become usual.
Because the government thinks it's a good thing.
Yes, because of the new government policy on first homes.
Okay, custom and self-build. Again, I'm not going to debate the facts with you, but I want to explore what the conclusions of weight can be drawn from the facts. So we need Mr. Moser's proof for that, and 2 points. First, so if you get his proof up first of all, tell me when you've got it. And could you please, when you have it, go to page 42. And Mr. Moser has there's 2 main strands to his argument. I just want to summarise them and say they're not contested, then explore relevance to weight. So page 42, he deals with the self-build register, which is how, of course, the council compliance with its policy and statutory duties in relation to the delivery of custom and self-build is monitored. And the point that Mr. Moser makes in the section starting at 416, suppression of the register belonging to Cambridgeshire, is that the council applies the local connection test, as well as a fee and retainer fees, local connection test for people who want to be on the register. And he sets out what that test requires at paragraph 4.18. He notes at 419 that the PPG requires a strong justification to be provided by local authorities where a local connection test of that nature is to be included. And he highlights why at 420, why the PPG says that. And then he notes that the council hasn't offered any justification, let alone a strong one, 4.21. And so the conclusion he draws is therefore that it's contrary to the PPG, to have that local connection test, and that has the suppressive effect on the amount of need. Again, none of that is contested. So that's his first point, that the monitoring is based against a suppressed figure, and it's right. There's no contradictory. No one contests what he says. We know that, don't we, Miss Greengrass?
Yes.
Then the second strand of his analysis is, well, how has the performance been against what the local plan envisaged for custom and self-build? And for that, we need to go to page 58 of his proof, which is entitled Performance Against Local Plan Self-Build and Custom House Building Expectations. And when you have that, if you could let me know, you should see a table, figure 6.1.
Oh, yes.
And what he does is he sets out, because a point often made with the council, well, we have a self-build requirement for the local plan. All we're doing is all this scheme doing is complying with it. But what he does is sets out what the local plan envisages in terms of self-build in that table, the various percentage for the allocations. And then what he goes on to say is that, you see, so I should say 6.3, an expectation of 288 to 300 service plots over the plan period. That's what's envisaged, 288 to 300 between 2011 and 2031, as set out in that table. And then when we go through to what's actually happened, we see figure 6.2. We see if you like, a progress track in the table in red against what was envisaged versus what's happened. And ditto at 6.3. And then the conclusion is made on page 66. And he says, 6.11, and again, this is not challenged, the council's strategy for delivering self and custom house building through the local plan hasn't achieved the desired outcome. 4 of the 11 allocations have made provision for 91 plots compared to the plan expectation for 182. One has made no provision, another appeared not to have done so, etc. And then cumulatively 6.13, he repeats the fact that the local plan envisages the delivery of 288 to 300 service plots for custom and self-build over a 20-year period. We're now halfway through that period and just 91 plots have been consented. So rather than half what was envisaged, only 32%. So it follows, doesn't it, logically, from this uncontested evidence that there is a demonstrable shortfall of delivery of custom and self-build against what the local plan expected. That's clearly follows from what Mr. Mosier has said, isn't it?
Yeah, so you're saying, he's saying there should have been 288 to 300, but there's only been 91. Is that what you're saying? Yeah.
Oh, so it'd be half that, so 288 to 300 over 20 years. I think to be fair, therefore 144 to 150 over the first 10 years has been 91. So there's a shortfall of about, give or take, 60 custom self-build compared to what the local plan envisaged. And a number of sites that were meant to have 5% custom self-build, the council let them get away with none.
Well, can I just...
Can you answer the question first of all, Ms. Greengrass? Say whatever you want. That's factually what you're saying, isn't it?
That's actually not factually correct.
Well, I'm sorry. How long have you had this proof? Have you not read it before?
I have read it.
Yeah. Well, we're proceeding on the acquired basis. This is unchallenged. And the time for challenging it has gone. And that, on the basis of what he says, it is plain, isn't it, that there is a significant shortfall of custom and self-build against the local plan, what local plan envisaged. That's right, isn't it?
There is a shortfall, yes.
And it's a considerable shortfall, 60 units. 32% of a plan expectation rather than 50%. I mean, it's a significant shortfall proportionally, isn't it? There should have been 150, there'd been 90. So it's a shortfall of give or take over a third.
If you accept his figures, my figures aren't just as bad as that.
I'm afraid that's the basis on which the inquiry has gone, because you've had an opportunity to challenge his evidence, and that opportunity's been and gone. And if we proceed on the basis of figures, we've got a considerable shortfall, and that shortfall means, doesn't it, that the local plan alone has not and will, based on what Mr. Moja says, the local plan alone has not and will not deliver the full extent of customer self-build identified as being required, even on the suppressed figure. That's right, isn't it? Based on what he says.
Based on what he says, but what he says actually isn't correct. His table is out of date. But there.
I'm afraid to say, sorry, I'm not simply not going to entertain that suggestion, because you've had a chance to say that and it's too late. Unless you want me to call Mr. Moja and the big cost application if you did at this stage. So the fact, based on what Mr. Moja says, the fact that there is this considerable shortfall, the fact the local plan alone has not and will not deliver the full extent of customer self-build identified as being required, even on the suppressed requirement figure, all of that is relevant, isn't it, to the weight that should be given to the contribution this appeal scheme will provide to the supply of customer self-build. Would you agree that it's all relevant to weight?
It can have an influence on the weight, but if I might just point out something else in relation to self-build, the council doesn't just rely on large site allocations to deliver self-build. We also have self-build houses that come forward independently of that. Yes. For example, if you look at the latest AMR that was produced, there were 14 separate planning permissions for self-build, and that equated to 92 self-build plots. That was between October 16 and March 21. So I just wanted to add that in, that we're not just...
If you read Mr. Moja's evidence in full, he takes complete, he points that out and he deals with those. And he notes that, you know, they're then counted by the council as part of its monitoring towards the suppressed requirement figure. So he takes all of that into account if you read the evidence from start to finish. Okay, so you've agreed that these points are relevant to the weight to be given to customer self-build. Can we then go to your proof? Because it's proof 7.13 on page 22. You don't take these factors into account, do you, in your analysis? You just say, well, 5%'s no more than what any development would offer, which actually isn't true in light of what we've seen, but also you fail to take into account, in giving only moderate weight to this factor, you fail to take into account that the requirement figure is evidenced as being suppressed for the reason we've looked at, and that the supply of what the local plan envisages as coming forward from allocations is considerably falling short. And that, as we've now agreed, based on what Mr. Moja says, the local plan alone has not and will not deliver the full extent of customer self-build required. You don't take those factors into account, do you, Ms. Greengrass, in your ascription of only moderate weight to this factor?
That's because, in my opinion, the sites are delivering what they're required as part of the policy. The sites are delivering 5% self-build. So therefore, this site could be any site delivering 5%. It's not above and beyond any other site coming forward.
Well, would you accept this? Would you accept this? I appreciate you perhaps belatedly decided to tell us that you don't agree with Mr. Moja, but if the inspector goes with Mr. Moja's analysis, if he follows what Mr. Moja says, then it would logically follow that he ought to upgrade the weight from moderate to significant, if he goes with what Mr. Moja has said, the factors that you don't take into account.
No, I disagree with that.
Why?
Because each site is delivering its 5% self-build. And why would you allow a site outside of the development boundary just to provide 5% self-build plots whenever the council's not reliant on that anyway? We have other means of providing self-build plots, which we do. which has been evidenced in the annual monitoring report.
But again, Mr. Famous Green, that's a completely unfair answer to my question because you're totally mischaracterising what I've asked. I can give you one more chance, and then I'll just move on and make submissions about your approach to evidence. So let's have one more go, if you don't mind. If the inspector accepts Mr. Mosier's evidence as being the appropriate evidence and reflection of the position in relation to custom self-build, you give moderate weight to custom self-build, failing to have regard, not having regard to the factors that he outlines, Mr. Mosier outlines. If the inspector were to add Mr. Mosier's factors into the balance on top of what leads you to give already moderate weight, then adding Mr. Mosier's considerations to your moderate weight ought to lead to upgrading this consideration to significant weight, shouldn't it?
No, I disagree, in my opinion.
High quality design. Have you read the evidence of Mr. Reynolds?
Yes.
Take up the framework, please, and go to paragraph 134. It's on page 40 of the framework.
Okay, I have the page, yes.
And do you see in A, there is reference to development which reflects local design policies, government guidance and design, take into account any local design guidance and SPDs such as design codes and design guides, yes?
Yes.
Insofar as there is any relevant guidance, the evidence of Mr. Reynolds demonstrates that the appeal scheme does all it can to meet the description of A, doesn't it? There's no falling short of any relevant policies and guidance in relation to design. There is complete compliance with it for the reasons he outlines. Would you accept that?
Yeah, certainly insofar as it can outline stage, yes.
Yeah, exactly. Well, and he to be fair, he does make clear with offers reference to design coding. There's various things that he outlines in his proof that can give the inspector comfort that at the reserve matters stage, the development will fall into category A, won't it?
Yes.
And so we can agree that development falls within category 134A, yes?
Yes, at this stage, yes.
At this stage and in future stages too.
Well, reserve matters would have to be tested when that came in, but at this point in time, it looks like
you could secure at reserve matter stage, you could secure a development that falls within 134A, yes?
One would hope so, but you don't know until you get the actual application in.
And if it's not good enough, you can refuse.
Yes.
So therefore, you can ensure that either nothing happens or whatever does happen falls within 134A.
Yes.
And that is something which the framework tells us in the last sentence of 134, significant weight should be given to.
Yes, I can see that.
Yeah, so that's a benefit that should be given significant weight in light of the new provision of the framework, isn't it?
It does say that, but I wouldn't say it's significant weight that would override everything else.
Did I say that?
No.
So try and stick to the question if you don't mind. Economic benefits. Let's go back in the framework, please, to 81. And could you also take up Mr. Hill's proof, page 56? Mr. Hill outlines, amongst other things, I won't read them all out, but some of the economic benefits he sets out in 56 and 57 include roughly 180 direct construction jobs, this is point 2, indirect generation of up to 270 jobs, meaning that overall in the region of 450. There's reference to a spend power of roughly, in point 3, roughly 5.24 million per annum. And these are matters which will support economic growth and productivity in the area, won't they?
Yes. Yeah.
And when we look at the framework 81, we're told in the second sentence what weight should be given to supporting economic growth and productivity. We're told significant weight, aren't we?
That does say that, but isn't that, I don't know if that's talking about actual employment development, not economic activity associated with building of housing.
Well, if you really want to go, there's a whole succession of decisions over the last couple of years on all sorts, from housing to care, sheltered housing, all of which apply this to any development which supports economic growth and productivity, Ms. Greengrass. It doesn't say only employment development, does it?
It doesn't say that, but that's how I read it.
That's how you read it, is it?
Yes.
Okay. What if that's not right? In the event that paragraph 81 is telling us that significant weight should be placed on any development which supports economic growth and productivity, if that's the right way to read it, it should apply to this development, shouldn't it?
Well, it could apply to this development, but equally it would apply to any development which is actually being provided elsewhere and so on within a plan-led system and not within a greenfield site. So that economic benefit would still happen if it was within the development boundary, not outside of it.
Why? So what? Even if that's right, so what? We're looking at the various considerations each side of the balance, and the framework is telling us this consideration is one that gets significant weight. Doesn't say you then reduce that weight if you can achieve it somewhere else. It says you give it significant weight, full stop.
That doesn't make this appeal site special, because you'd still get that economic benefit if you were inside of the settlement boundary. It doesn't make this appeal site somehow special.
Could you stick to the question? I mean, I'm simply asked. I'm trying to tot up benefits on various sides of the balance, and this is a factor which must be given significant weight in favour of development.
I don't agree. I stick to what I said in my proof of moderate weight.
And the point I think is alluded to in your proof that construction jobs are temporary. So I just want to ask you a couple of questions about this. I take it that you would accept that the construction sector plays a fundamentally important role in the UK economy. Would you agree that?
Yes.
And would you also accept that the construction sector in that important role in the UK economy is entirely dependent on a continuous pipeline of temporary projects, isn't it? That's the nature of construction. You go from job to job, yes?
Yeah.
And so therefore, developments which are temporary are the only source of supply to that pipeline of work which feeds that fundamentally important construction sector. That's right, isn't it?
Probably, yes.
Okay, I'm going to now ask you about the tilt. So I think you said in chief, albeit for the first time, that if there was a lack of a 5-year housing land supply, you would accept that the appeal should be allowed. Did I hear that correctly?
Yes, because if there wasn't a 5-year housing land supply, the tilted balance would come into play.
Yeah. And so your position is that, if I understand it, is that if the tilted balance is in play, meaning that rather than on a flat balance where it would be, of course, the question one is, are we in accordance with the plan as a whole? But if we're not in accordance with the plan as a whole, the onus would be on us to justify why we should get permission, why material consideration indicate otherwise. Whereas in the tilted balance, it would be on the council to demonstrate why we shouldn't get permission, why the adverse impacts significantly don't outweigh the benefits.
Yes.
And it's effectively that switching of the onus, which you see as meaning that you wouldn't be able to resist the appeal in that situation, is it?
Well, you'd have to demonstrate that the harms outweigh the benefits.
Yeah, rather than the other way around. Understood. And tell me this, it must follow then that you would accept that also, not just if there wasn't a 5-year supply, but also if the most important policies are out of date for other reasons. We'd be in tilted balance territory there too, and that would also lead to the downward appeal, wouldn't it, on your logic?
Yes, if the most important policies, if most of the important policies were out of date, then the tilted balance would also come into play.
So if the tilted balance is in play, irrespective of why, then the appeal should be allowed.
Yes, if the tilted balance comes into play.
And if the tilted balance is not in play, so the onus is, and if there's non-accordance to the development plan, then the appeal should be dismissed, is how you see it.
Yes.
And presumably you would accept that if we are in accordance with the plan as a whole, you're not saying there are material considerations that justify refusal, are you? That if they're in accordance with the plan as a whole, we should win also.
Yeah, if it was in accordance with the plan as a whole, then there would be no conflict with the development plan.
I just want to understand this. So really, as you see it, I'm not saying this is how we see it, as you see it, it all turns on how the balance is struck, whether if it's a flat balance and we're not in accordance with the development plan, we lose. If it's a tilted balance, we win. That's decisive, as you see it.
Mm.
Yep.
Yes.
Now, if that is the case, that it all turns on whether it's for us to make good why we should get permission, not in accordance with the development plan, or as opposed to you to say why not, it must, even on your own analysis, with your own weightings, your own thinking, even on your basis, it must be pretty close call. It must be a pretty close case, this, finely balanced in a flat balance. If it's so close that once you tilt the balance, the ball rolls in our favour. Even on a flat balance, it must be, we're not a long way away from getting permission. It's a fairly finely balanced judgment, isn't it? On your own analysis, Miss Greengrass.
No, I disagree. It's not finely balanced. It's
Right.
Clearly, if you look at my brief, it's clearly contrary to the very heart and core locational strategy of the development plan, and you can't get away from that. So
I did look at your proof, but you don't make this point in your proof. I'm just struggling to understand how that can be reconciled with your approach that if the tilted balance applies, we win. So you change the balance, and that makes all the difference. That must suggest that, because the tilted balance isn't that much difference. The tilt isn't like that. You go from flat balance to like that, and that makes all the difference. That rather suggests that even the flat balance scenario, even on your analysis, it's fairly finely balanced, doesn't it? It all turns on the onus of proof.
no,
Well, either that, Miss Greengrass, I'm bound to suggest, you haven't thought this case through very hard. You haven't really given this proper bout of thought, have you?
I actually have.
Right.
Mr. Banner, I'm just looking at the time. Do you have much further to
No,
go?
I'm just looking whether I've got anything more, sir. I don't think I have. I think everything else can be dealt with in submissions. Thank you.
Right, okay.
You read my mind, sir.
Right, okay. Just bear with me for a moment while I check my notes. Right, Ms. Greengrass, one of the things that the appellant has pointed out is that there was a scheme considered by the council at Littleport, where Growth 4 was considered a 680 dwelling scheme. The broad location was something which the council considered. Can you just tell me a bit about what's different about this site and why you're not similarly following a similar sort of policy approach here?
Yes, sir. That site at Littleport, the decision on that was made some time ago. That went to planning committee. I did make a note of it because I thought you might ask. That went to planning committee in December 2017. So that's quite some time ago. And that's when that recommendation was made to the committee to approve the application. Now, at that time, the council did not have a 5-year housing land supply. So that was in the mix. But also at that time, we had the proposed local plan, which is now withdrawn. That was at a fairly advanced stage of preparation, and within that plan, this particular site was allocated for development. So some weight was given to the fact that that was an allocation in the proposed local plan. So that's why that particular site was recommended in that way. So sorry, at that time, that planning officer made that judgment based on those factors. So yeah, things are materially different now. That's the point. Yes.
Thank you. And then I just want to ask you, we're obviously going to have a talk about planning obligations in due course, but I wanted to ask about the affordable housing offer, the enhanced offer, as the appellant calls it, over and above the policy requirement. And I did ask both parties to give a view on that before I opened the inquiry. I had a written response, and your response to that was that it is not necessary to make the development acceptable. Can you just tell me a bit about that, and whether I should, in your view, be attaching any weight to the level of affordable housing above the policy requirement?
Yes, sir. As I said before, when you asked the question, you're correct. It's not needed to make the development necessary. And in any event, it's only 10 more houses. Well, I wouldn't give that any more than significant weight, because 10 more houses in the grand scheme of things is not especially significant. If it was, say, 50% or a much higher number, then one might be persuaded to give it more weight. But I just think it's only 10 more houses, it's another 6%. And so my view is, my judgment is that the weight should still be significant, not above that.
And if I were to attach weight to the additional affordable housing, would that be in accordance with the SIL regulations?
I'm not sure, sir. I suppose
one of those being that
it has to be reasonably necessary. Is that what your point is? Yeah. No, but is that your
development acceptable? Yes.
Yeah. What one? Yes, certainly. I wasn't sure that's the point you were making. So yes, I agree. It wouldn't be necessary to make the development acceptable. So in that way, it wouldn't meet those terms.
Right, okay, thank you for that. Mr. Smythe, do you have any questions in re-examination?
So just one question. At the start of your cross-examination, Ms. Greengrass, it was put to you that the strategy for delivering an out-of-date requirement meant that the strategy itself was out of date. So effectively, Grove 2 infects Grove 2. Sorry, Grove 2 is infected of out-of-datedness because it is providing for an out-of-date requirement under Grove 1. And you said in response that even if the housing requirement figure went up, it wouldn't alter the locational strategy. Can we take up Grove 2? So it's core document 3.1. I think it's page 25. Yes, yes, 25. Are you there, Miss Greengrass?
Yes, yes.
So if we look at growth 2, we can see it's got 4 paragraphs. So the first paragraph is the 3 towns. Next paragraph is the villages. Third paragraph is of development to meet local needs. Then the fourth paragraph is outside defined development envelopes. Do you see that?
Yes, yeah.
Yeah. The existing annual housing requirement in accordance with the standard methodology is 646 dwellings a year. So for the sake of argument, let's imagine that growth 1 is reviewed, and at the end of that process, it's decided the housing requirement is in fact 700 dwellings a year. Looking back at growth 2, can we work our way through those 4 paragraphs? So if the housing requirement goes up to 700 dwellings, would it alter the first paragraph? The majority of the development will be focused on the market towns of ...
No, that would stay the same.
And let's look at the next row in the pyramid. If the housing requirement goes up to 700 dwellings, more limited development will take place in villages which have defined settlement envelopes, thereby helping to support local services, shops and community needs.
Again, I can't see that would necessarily, I can't see that would change. It's still, that would still stay.
Yeah. Thank you, sir. That's all the questions I have. And so that concludes the case for the District Council.
Right, okay. Thank you. Thank you for that, Ms. Greengrass. That probably brings us to the end of what we need to cover for today. There's a couple of documents that have been submitted. A draft SIL compliance statement was sent by email, so thank you for that. It's titled draft, but is there to be another version of it, or is it the final version?
As the version, yes.
Right, thank you. And there's also the appellant's response to the interested parties, which we talked about earlier. So can I just check the council has seen that? Yes, good. Right, thank you. So they can be added to the interested parties. So the inquiry documents list, please. In terms of how the remainder of the inquiry will run, we'll hear from the appellant's planning witness tomorrow morning, and then we'll deal with the planning obligations and conditions roundtable session after that. And then I imagine that it would be best to leave closing submissions until Friday morning. Is that what advocates have envisaged? Or
I mean, I don't much mind, to be honest. So I was waiting. Mr. Smythe had a discussion, really wanted to know whether you had a preference. We're very happy either way, to be honest. I think slight preference to do it Friday morning, given we haven't started, Mr. Hill. But if you had a great desire to finish tomorrow, then we could probably accommodate that.
no, Mr. Smythe, you're in agreement with that?
Yes, sir, I agree. If we really put our shoulder to the wheel, we probably could finish it tomorrow. But provided you're not desperate to finish tomorrow, I think probably we would have a modest preference, like Learned Friend said, to finish on Friday. Yes,
okay. Well, I think that's fine given the timescales that we've got. So we'll deal with appellant's planning witness, conditions and section 106 tomorrow, closing submissions on Friday morning, and the site visits then on probably early on Friday afternoon. So I don't know who's going to be involved with that, but we'll make arrangements for it. So just as long as everybody's aware, it will be on Friday afternoon. Okay, anything else to raise before we adjourn for today?
No. Thank you, sir. Good night.
All right, thanks very much. We'll adjourn now.
Is it 9:30 tomorrow, sir?
Yes, until 9:30 tomorrow morning. Thank you.